Welcome everyone. Mic's on now. Good to see so many people here. My name's Lee Bygrave. I'm the chair of this panel session. I'll also be the moderator because Seda Gürses, who was originally supposed to be the moderator, has been unable to make it to Brussels for health reasons, so I'm stepping in as moderator. No big deal. I've always thought the distinction between a chair and a moderator is rather artificial. So less red tape. So we're gathered here this afternoon to sort of talk about some new, innovative and definitely enigmatic provisions in the GDPR. These are the provisions in Article 25 dealing with data protection by design and by default. And with this nomenclature, we're in a way entering new territory, because for those of you who've been following the by design or regulation by design discourse over the last 2 to 3 decades, and it is a long discourse, you'll have seen that this notion of data protection by design and by default has just come in with the regulation. Previously, we've been talking, well, way back in the 90s, we were talking about PETs, privacy enhancing technologies, which had a close relationship with SETs, or security enhancing technologies, and one also talked about their opposites, as in the form of PITs, privacy invasive technologies. And that discourse then later morphed into this one around privacy by design, popularised by Anne Kavoukian, former Commissioner of Data Protection for the province of Ontario in Canada, and a nomenclature that was taken up eventually by the rest of the data protection regulator community, particularly in 2013 at the annual International Conference of Privacy and Data Protection Commissioners. So that was privacy by design, and in recent years we've seen also talk about privacy engineering. And I had the good fortune of attending the panel organised before lunch in this same room around privacy by design, and a lot of the talk then was also about privacy engineering, where one of the proponents of that term was saying privacy engineering takes privacy by design one step further. It would seem to be more about the actual, the mechanics of realising the rather lofty and somewhat nebulous goals of privacy by design. But now we're dealing in this EU context with data protection by design and by default, and one issue arises, is this the same thing as privacy by design? Is this the same thing as PETs? And I would say it's not, that data protection by design and by default is something else, something somewhat different. There's a lot of commonality, but nonetheless there is something different, and I think my panellists will also elaborate on this in their respective talks. So Article 25 is a lengthy set of provisions. Has anyone, I know some of you have read those provisions. They are in the form of 3 paragraphs, and the first paragraph deals with the design aspect, data protection by design. And the second paragraph deals with the default aspect, but has a distinctly security focus, so more concern about achieving a state of somewhat absolute data confidentiality. So it's concerned about keeping data lean and not leaked. That's 25.2. And then 25.3 is all about certification mechanisms, which we'll touch on in this panel session, but it won't be very much in focus, because that's something further down the track. And one question is, well, what exactly may certification mechanisms play in the realisation, what's a role may these mechanisms play in the realisation of the ideals of Articles 25, 1 and 2? So the mechanics of this session are that we have 4 very distinguished learned speakers, panellists, each of whom represents a different perspective on the topic today. And each of them will provide a sort of 8 to 10 minute, no more, prepared talk on their respective takes on Article 25. And the panelists are, as you can sort of see from the program and the name tags, Barbara Vieira, Bert-Jaap Koops, Marit Hansen, and Woody Hartzog. And the order is, you know, there's no particular logic here, but I thought, well, we'll start off with Bert-Jaap, who's perhaps going to present the somewhat cynical, perhaps jaundiced ivory tower perspective on this newfangled provision of the GDPR. Bert-Jaap has with him the benefit of several decades of looking at this sort of regulatory strategy, this sort of discourse, so he brings with him quite a bit of experience to bear. Woody is our US representative, so he'll be bringing a somewhat provocative set of warnings, perhaps, from across the pond. And then we have Barbara next out, who will bring a perspective from the engineering community and also from the business side, because Barbara is a computer scientist who is also now working for a business that is trying to leverage some profit from this nascent area of development. And then finally Marit Hansen, who I'm sure is also someone very familiar for many of you here in this room, who will be representing the regulator's perspective. She is the Data Protection Commissioner for the German Land of Schleswig-Holstein. So Bert-Jaap, take it away.
Thank you very much. Surprisingly, I was planning to be constructive rather than cynical today. And because of the short time frame, I'll supposing that this looks that was already too much. I have 2 points to make. In the first part, I will elaborate my take on the design part of data protection by design and connect that to privacy by design. In the second part, I'll go on to discuss privacy, and I will not spend more than 30 seconds summarizing the 128 years of thinking on privacy. So I'll try to remember within 8 minutes, 10 minutes. This is Article 25, as explained. We won't read it, but there are 2 elements I want to focus on in my talk. The first is that data controllers should take into account the rights and freedoms of natural persons at the time of determining the purposes. So very upfront at the beginning when you start thinking about new types of processes. The second element is the issue of data minimization, which is tricky to do, and I'll try to combine that in the second part. So rights and freedoms, you have to take those into account. That, of course, includes the right to privacy. So conceptually speaking, if data protection by design implies that you have to take into account all the rights and freedoms, you also have to take into account the right to privacy. So that would imply data protection is broader than privacy by design. It raises a whole lot of questions on all the other rights by design that you might also then want to take into account. I'll focus just on privacy. And one particular description of privacy by design that I like is by describing it as protecting privacy from the conception of a new technology up to its realization, with the idea that when you do that in the whole development stage, from the start to when you launch the product, then also in the rest of the life cycle, privacy will be protected. The cynical part in my previous research is that I was very skeptical on whether you could hard code privacy rules, because obviously privacy rules are written and expressed in natural language, which is open, flexible, ambiguous, whereas software rules are rigid, or at least should be unequivocal. And there's a great gap between them. So in the past I've been arguing that hard coding privacy is not possible, but that implies that we should look elsewhere, or at least we should broaden the perspective. So looking at by design, it's not only privacy better. All kinds of issues with nudging and journalism, but at least it might be worth a try. And also what I find particularly interesting is to think about designing the environment in a way that privacy is protected, which I don't think is usually considered within the concept of privacy by design. But one very nice example are these nice buttons. Not everyone will see that, but we have buttons that can indicate whether or not you want to be photographed. It does not do anything about the design of cameras. It doesn't do anything about the design of facial recognition software, although there should be an element that these buttons should then also be recognized. But at least it's a way of putting things in the environment that then technology can take up and do things with. So I think that is one way of broadening up the perspective, not only looking at the single devices or the data processing as such. The other thing is that design is also a process, and maybe this is, and also in the description by Anna a bit more the focus. Look at privacy in the whole development process, and we can learn a lot from the developments in value-sensitive design already for 20 years, and now the past 5 to 10 years, also very many examples of responsible research and innovation with all of their methods, etc. So that is what I wanted to say about the design part. Now about privacy. As I said, I won't summarize 128 years of thinking about privacy, but just present what I presented last year also here at Cpdp. The typology I developed because this illustrates the point I want to make here, that privacy is more than data protection, which is graphically illustrated here by data protection being in the gray middle zone. Privacy is always also about data, your data, and it also has an informational component, but it is almost always also about something else that is not reducible just to the data that are being processed. And I will focus briefly on one element, spatial privacy, to argue that privacy is more than just the data. If you look at the classic way we protect spatial privacy is fairly obviously low, where you can be yourself. And it's not only the fact that people don't exactly know what you're doing within the limits of your home. It's also just the feeling of being comfortable inside your own home, and I don't think that is reducible to data as such. And if you want to protect privacy, then that feeling of feeling comfortable in a certain space is, I think, quite important. Now, the problem is that the home is classically protected very physically against intrusion, so people coming inside the home and then doing things there. And I don't have to elaborate much that is 20th century and in the 21st century, the walls of the home don't shield much. People can look from the outside inside without entry. The whole development of the IoT will mean that many processes in the home will also leak out data outside of the home. And we should also realize that the things we used to keep in the home, we still sometimes keep them, but many of those things, the books, music, letters, administration, what have you take with you on your smartphone and your phone. So what is needed is to think about a home 2.0. I'm with the team conducting a large-scale project now in the 4th year of coming up with new concepts that might protect privacy in the 21st century, and I think that the notion of home 2.0 might be a productive notion there. And one thing I wanted to bring on the table here is that notion of a cybernetic home. I take that from my Italian colleague Lorenzo, who somewhat difficultly perhaps, but I think illuminatingly describes the cybernetic home as being able to exercise the use exclusivity, the right to decide who you want in and out. In your cybernetic space, that is the whole of the devices that you have and the data therein, over which you have exclusivity rights. So P.T. expands the notion of home to digital space that you can call home. And that basically means that data in the cybernetic home should have higher protection than data in cybernetic public space. And the point is, what is the cybernetic home? What is cybernetic public space? That is something I will try to develop in the next year and a half. But what I need there is also some privacy by design. And this is the challenge I want to put on the table here for the engineering and policy community. I would like to protect Home 2.0 in the law.
Before we move on to Woody, Bert-Jaap, I'm just going to challenge you a little bit. Conceptually, you started off by saying that privacy is more than data protection, because privacy has, for example, spatial elements in it that data protection, at least on its face, doesn't envelop. But then later on you talk about Home 2.0 and the cybernetic home. And if you think about what are the building blocks of the spaces there, they are consisting of data. So my question is, aren't we then sort of going back on your original assumption and saying, ending up with the conclusion that, well, the privacy protection is inevitably going to be a function result of the data protection? So we're back to privacy and data protection being somewhat commensurate.
Instead of focusing on what is inside, you just protect the borders of the space to protect what is inside. And a home can be protected regardless of whatever you have in there, including very public things. If you do public things in your home, you still have home protection. And I'd like to take that concept and also translate that to smartphones and cloud systems where that might happen.
Okay. One other question which you can only answer in 30 seconds. It's a bit unfair. But do you think, with your final question, suggestions, that Article 25 is providing the right stimulus, the right catalyst for solutions to your Home 2.0 dilemma? No. Okay, fine. Right. That said, let's move on to Woody, who's Professor of Law and Computer Science at Northeastern University in Boston. Welcome.
Thank you very much. It's a pleasure to be here. I gather most of you by now probably come wise to the fact that the term privacy by design is one of those terms that everybody talks about, but nobody knows exactly what it means, like big data. We all throw it out, but when you ask, what do you mean by big data? It's a lot of data. And so means only or substantively do the fix sooner of fair information practices, which is largely what I think it's conceptualized as, then we're missing out on two things. One of those things is that the traditional fair information practices have blind spots. I agree with Bert-Jaap. There are things that data minimization, notice, transparency, these traditional fair information practices simply don't cover. One of those blind spots, which Bert-Jaap alluded to, is manipulation. People are increasingly subjected to attempts to frustrate their free exercise of choice in online environments. We are subject, there are two technologies in particular that I'm thinking of. The first is the user interface of mobile apps and software on laptops. They're being used to provide notice, and I'll use the steer quotes for notice, because it's not really notice. They present things, you agree to things, but you didn't create the choice structure. You're sort of asked to the binary yes or no. And the other thing is artificial intelligence, anthropomorphized artificial intelligence particularly. I'm thinking of things like home assistants, like Alexa and Google Go, and things that are able, you almost form a relationship, right? So we become friendly with them, we talk with them. Hello, Alexa, oh, you made a joke. You know, my kids think it's hilarious, and they think that Alexa has a personality. And then, lo and behold, you know, one day Alexa is offering, you sit and tell Alexa, I'm really trying to quit smoking. Can you know, recommend some nicotine patches for me? And Alexa says, you know what, I've got a really good deal on cigarettes right now. Is that a violation of this? It's not really, doesn't fit squarely into what we think of as data protection, but it is a growing concern if this really don't address that. And so if privacy by design means that, then it strikes me as something of a problem. The other blind spot is our susceptibility to algorithmic decision making, which I won't talk much about because there's probably at least 7 panels here that's getting into that. But the idea that we are subjected to decisions that are made about us that we have little idea about, and certainly very little understanding of how they work is a problem. And the standard fair information practice is really going to address when that's a problem. Right? So to what degree, when we're being manipulated, is it a problem? To what degree, when we are decisions made about us, is it a problem? And then, of course, there's the competition problem. So there are blind spots. And so I'm left a little cold if data protection by design and by default is only the fair information practices. The other problem that I have to say I would push back against, and I hope that data protection Article 25 doesn't get interpreted only in this way, which is that it doesn't solve what I think is one of the Achilles heels of the entire data protection endeavor, which is the problem with consent and the problem with control. Control is easily leveraged through user interfaces to transfer risk onto data subjects under the auspices of recognizing people's autonomy in decision making. I love the idea of a privacy by design that seeks to make data protection the default state, but when the entire sort of enterprise is built upon this notion of giving control to users, then it sets up a trap. Right? It sets up a trap where that control is gifted to us in such quantities that it becomes almost meaningless to us. And then the value that we sought to preserve is then basically eroded. Now, I brought this discussion up before, and the response is, well, you just weren't paying close enough attention to Article 25 and what we mean by, and really the GDPR, what we mean by consent, because it has to be meaningful consent, informed consent. The problem I have with that is that even if a technology company perfected consent and made it so that every decision was sort of perfectly displayed and we had a full understanding of what was going on, we agreed to it with sort of full So in conclusion, what I want is a little bit more of a push beyond the fair information practices for privacy by data protection by design and data protection by default. It needs a better normative core. It needs to identify the values that it wants to protect besides control, besides consent, perhaps trust, perhaps some other sort of value that can help us move beyond the consent route. And to the extent that it focuses on technology besides data, we should focus on things like user interfaces and artificial intelligence.
Thanks, Woody. I'm just going to ask a very quick question, and I want a quick answer, 30 seconds. If you look at Article 25.1, do you think it has the potential to be interpreted in a way that would go beyond traditional FIPs?
Yes, yeah, I do. But I think it's going to take, a lot of difficult conversations.
I don't want those qualifications now. Okay. We'll leave them to later. Okay, thanks. Barbara. Over to you, yes?
So, thanks for the invitation and for having you here today. So I just want to give a bit of a context of what I do and where I come from. So I work for a company called the Software Improvement Group with the headquarters in Amsterdam. And I think we are one of the companies or the few companies in the world that believe that we can make software better. So we have a set of tools and people and models where we assess software in a more structured way, and we help people improve the quality of the software by giving advice on guidelines on the things they can actually do in practice to improve the software. So in this context, more or less 2 years ago, we came up with the idea of looking at privacy. So we were already looking at security and assessing security of software systems and helping teams across the globe to improve the quality of their security or maintainability of software in general. But we wanted to look at privacy. And so this was a bit hard in the beginning, and it still is. So we are still building up on our idea because there's a lot of challenges in this. And if we look to the Article 25, so Article 25.1, it says that we need to implement measures to enforce the privacy, the data protection principles, but this is not concrete enough. So, for instance, if we consider anonymization, what is enough? What can we actually do to de-identify or anonymize the data? And although there's a lot of research on privacy-enhancing technologies, these are not really mature, so it's very hard to place these techniques into a specific context or use a technique that is actually mature to enforce privacy by design or data protection by design. On the other hand, we also see a lot from the industry side that for security already, the development teams are not mature enough. So to implement a secure development process, it requires a lot of maturity. And most of the teams we see in the market, they don't do this. So the question we ask is, how can we expect them to implement privacy by design, which we consider to be a very straightforward concept, but it's very hard to implement because the guidelines are not concrete. So we could consider that we can look at this from a more broader perspective. So we could say we could use the tools that are already there. For instance, we can do a data protection assessment and see whether the system is compliant or not. But this doesn't give you guidelines, concrete examples of how to protect the data or protect the privacy of the user. So The other thing we notice is that many software, many companies believe that they are already privacy or data protection compliant because they implement security. So this is a concept that is widespread. So if you talk to people, to companies, they say, "Oh, we are secure. We don't have any data breach, so we won't be fined." So we implement data protection by default and by design. And this is a bit of, I believe that this is a bit of lack of awareness of what actually data protection is. And also, it's also easier to understand it in this way, because the major concern of the software companies is, am I going to be fined? Am I going to have a data breach or not? And I think Marit is going to talk a bit about more this, right? So this is the area of the DPA. So I think to summarize, there are many challenges that we are facing now, especially because there's no tool support for developers to help them understand how they can actually implement data protection by design. And what we actually look at, what we aim for is that, and what we see that the data protection the legislation doesn't bring is the how. So how can we actually do this? We need to be more concrete, and the law is not concrete at all, because if you ask to a lawyer, can I store this data or can I process this data? They will say, well, it depends. And that depends for a software engineer, it doesn't work, because if we implement software in the right way, there's no way of implementing it in a dependent way, right? So it's either yes or no. So basically, that's what we would like to see, and we leave the question, and I think. Yeah, I can finish my 5 minutes introduction. Thanks.
Thanks, Barbara. And on your last point about the "it depends" answer by lawyers, the "depends" bit is in itself reinforced by the wording of Article 25.1, which lists a whole range of contextual factors that are going to modify, qualify the need to implement the data protection by design. Yeah. Okay, Marit.
Thank you very much. Can we have the picture of the slide of the Article 25 here again? Thank you. So we will finish. So it's not that pessimistic here on the panel. In the preparation emails I read, I was the only optimistic one. Because it's so easy to do some bashing to the GDPR. Of course it's too abstract. Of course there are many deficiencies. But now at least I have to work with it. And probably I would love it to use what is there really do something in the sanctional field? Is it now that bad that it's really, well, if there's a high risk, then you get other provisions already where you can do the sanction upon. But with Article 25, if they did everything right, only they ignored Article 25. So I cannot imagine that this will be then the best case. But still, everything where there is a sanction has now become visible. So people think now, the first time, maybe even in Germany, think the first time about data protection. Because now media coverage is so obvious. Because there are so many service providers, spreading panic. And this obviously now gives attention also to Article 25. And if you read this article, yes, there it is. When you see, it's about the principles of data protection, it's about the GDPR, and it's about everything, the rights and freedoms of the natural persons. So if you only take this seriously, then you have everything. But of course, it's so abstract and so few words. How can we deal with that? And there's another deficiency. It addresses controllers. Yeah, okay, not processors, not producers. But of course, controllers have to choose from the market. And there's a provision in Article 25, paragraph 1, that it's about state of the art, what is available. And if nothing is available, then there probably won't be any progress. But the controller, of course, has responsibility. So they have to ask for that. For example, recital 78 says, in procurement, if you are choosing your means for data processing, keep in mind the GDPR, especially Article 25. And so we are now checking ourselves and the public service, for example, in Schleswig-Holstein, about how do they do their procurement. Did they ask for data protection by design? What was data protection by design with regards to the purpose they have? So the competing companies will now write a paragraph, and they don't know, of course, about the competing companies. They have to argue why they took Article 25 seriously. So this will be, again, something where it's attention, visibility, and something to compare. Of course, if this is only one thing where this competing company is very good at and the rest is crap, then it won't be chosen. But if it's on the same level as the others, and this is the thing, it can be a competitive advantage. The same for processors. So the data controller has to make sure that the rest is also happening. There's also, again, one efficiency. See, what about browsers? Something where there's a direct purchase of the consumers. There is hardly an answer. If there's not a data controller, but only a software manufacturer, then this provision is not sufficient. But we are looking into the privacy drafts, the privacy regulation drafts, and there will probably the manufacturers be addressed. Again, what do we expect from them? But this, again, will be closed, I hope. And then, when I first read this very abstract stuff, I was so disappointed, reading the first part here, seeing so many limiting conditions. So it's about state-of-the-art, implementation costs, really looking into, taking into consideration, and so on and so on. And I thought we will never get there, that it's clear that somebody has to do something about it. But we have the accountability provision. So the data controller cannot ignore it. They have to show that they took it seriously, so that they have to document. I want to see the page as a regulator. What did you do about data protection by design and by default? Please show your documentation. Oh, you didn't do anything. Why? There was nothing on the market, but I know it was on the market. Why didn't you do it? So something like that, where we can have this talk and see whether there is something or not. It's not about the best solution. It's only about something where the risk can be coped with. But again, it's a risk, and I hope very much that we can a little bit extend our traditional notion of personal data and only the individual to what is also manipulation and group discrimination, for example. That these are also risks for this is meanwhile state of the art, and there have been sanctions in many parts. So this is now a law about. You have to read this. So we have to get into this field where it's clear, you cannot ignore, you have to document, I want to see it, and then we can lift everything to a better level. And this is also good for those companies and researchers who have done work there, because there's such a huge gap. So many good ideas for 20 and more years, and hardly anything on the market. But why? Because it was not necessary to take them seriously, and now I think the playing field is not level, but it's getting there. And so even the small companies may be better off now if they do something in this area and can evolve and offer something, and that the big players, again, they also have to put in everything there. But it depends, of course, on what is available, on what is not only a research idea, but really something you can work with. And so my call is to you, I want the solutions, I want to build really good solutions, and please make aware your DPAs, they are not used to think in these categories. And we DPAs have to learn, but then we have something where this abstract text can be, perhaps blossom with something where we see it's now doable, and we will see that we will have some enhancement in the level of data protection. Thanks.
Okay, now over to you people. Time for curly questions. Charles, you had your hand up first. There's a roving mic. Good.
Charles Rabb, University of Edinburgh. Thank you very much, all of you, for very, very penetrating talks in one way or another. What I want to ask about is something which has been bothering me for a long time in data protection law, and it goes back a long time. And you see it in both paragraphs on the board. It says appropriate technical and organizational measures. I've never really seen any serious discourse about what organizational measures might mean. It's always interpreted as technical measures, and the examples given, for example, pseudonymization. It seems to me that if one were to want to develop this flower so it'll blossom, one can think of what organizational measures might mean, and it might mean the way in which a company is organized internally to relate the privacy and IT stuff to the management board and the executive board. It might mean certain kinds of roles and employees, maybe data protection officers. That could be an appropriate measure for ensuring the things that they're supposed to ensure. Now, first of all, am I on the right track with that? And secondly, why has it been so absent for at least 25 years in data protection law? In other words, the thinking about organizational measures.
I always thought that the two came together, so there are very few things that are purely technical. They always have some kind of organizational component. There are very few things that are only organizational and have to be backed up. And for me, the typical example is access control, which you have with passwords, and you have then certain roles that certain people with access rights can only access those data, and other people cannot, which is a combination of technical and organizational needs. But I think I have a good example with the recent, or about to be adopted law on police hacking in the Netherlands. It's still in the Senate, but we assume it will apply. One of the measures they took there is that the person responsible for having installed malware on a suspect's computer and then monitoring what is being done there are not the ones who are involved in the investigation. So they collect data based on the remit of the warrant, and the data set is then given to the people who are investigating the case. And that, I think, is a very good organizational measure. There's very little technical in there. That ensures at least that you won't have fishing expeditions of looking a bit more beyond the warrant, because the people doing this are not interested in that.
Good. Marit, you add something there?
Yes, and another organizational method, because we believe that there are many more organizational measures than the technical measures, because usually we I heard a good thing for really integrating something into your product design phases. And this means that you have to apply for money within your company if you want to go into the next phase for your product development. And how do you get this next, the release for the next stage? Only if you can prove already, and then there are always some compliance issues. So you don't get the money to do the development if you cannot prove that you have tackled already some of those issues. And it's more about coupling with financial issues and perhaps also power issues to behave and you're compliant with data protection. It's not a just typical security thing, where like having different entities.
Okay, thanks.
One really quick example that you could draw from the very first time that I heard someone talking about privacy by design in the United States was when the Federal Trade Commission required what they call a comprehensive privacy program as part of one of their settlements. And those typically include what you might think of as organizational protections. One of them is hierarchical, meaning someone, institution, or organization has got to take charge of this. We need to figure out who to point the finger at. A lot of them are assessment-based, so do PIAs, do analyze your data. And then some of them, one of the arguments that I like to put forward, though I haven't seen it quite be articulated this way, but perhaps it has, is an organizational requirement to me would include resource allocation. It has to be money.
Okay, thanks. There was a... Okay. Whoever's got the mic?
Yeah, got it here. It's a question for Bert, actually. I find your concept of Home 2 really interesting. How would it deal with this real-life fact? So someone may have bought a Nest thermostat, and approximately over 1 year ago, Nest changed its terms and conditions in its favour. And in big capital letters, because Americans like to do that in case you're stupid and can't figure it out, it says, if you don't agree with this, disable your device and stop using our services. So how does Home 2 deal with that reality? I mean, I was lucky that I managed to get the retailer to refund me the purchase price of my product after nearly 2 years, based on that imbalance of power.
It's complicated, and I still have to consider the relations between Home 1.0 and Home 2.0 and how I conceptualize that further. To clarify, when I talk about Home 2.0, I mean a kind of equivalent to the classic home, and I don't necessarily mean the classic home in its digital manifestations. And the example you give is primarily one why I say that Home 1.0 doesn't really do much anymore, because in this case, Amazon can look inside, and you consent. So in this case, it's not really a violation of your home, because you have consented to allow Amazon inside your home. Therefore, I would also say that having such providers looking over your shoulder is primarily not something that I would want to protect with Home 2.0. It's a significant problem, obviously. But I think we need other types of privacy concepts, which I'm also trying to develop alongside this, to tackle that problem, particularly of service providers who really have considerable access rights over your data. And I think that is a distinction to be made between what, for me, the core of Home 2.0 should protect is typically those things that you do not want to share with others. And sometimes when you store them in the cloud, there is still this provision in the terms and conditions that under certain conditions, the service provider can access them and give them to law enforcement or what have you. But your photo albums, your digital books, your music, if you're just storing them in the cloud because it's cheaper than storing them on your hard disk or putting them on the shelves in your home, I think that is typically what I would like to protect with this Home 2.0. And therefore, the whole debates about IoT devices and domestic appliances is a bit of a different issue that I'm not necessarily trying to solve with this concept.
Yes, hello. My name is Kyle Erickson. I'm wondering if any of the panelists can speak to how regulators assess what is the state of the art in privacy by design and how they validate the claims made by technology providers who claim to provide these kinds of protections.
Probably one of the regulators is me. to involve the academic area, because otherwise those who are doing the regulation all day, they usually don't understand all the fine differences, and we are already now overwhelmed with requests from technology providers saying, oh, we are the best, and look at our snake oil. And this is something where it's really hard to differentiate, and it's already hard for researchers to do that, although they're right in the middle of what is happening. And we did some maturity checks together with some researchers, like a peer review organized, and to see whether they could get together. We had 10 criteria and also some ISO standards, and we did some, there's a report from NISA on that, how to deal with that, to have the quality assessed and the maturity. Because it's not only to have something which is on the market, but then it does not work that way, or may have some side effects which are not desired. But it's also not so good to have something which is so beautiful, but it can never happen. And also, is there a prototype? Is it really resilient? Can it work? And it was interesting because the reviewers could not agree on each topic, but they could have some assessment, and then where they really divided in their assessment, they could argue and then write simply down why they chose that value. And so this brought us forward, because then we understood that there might be agreement or not. So 90% was clear and 10% was, but it depends really very much on, and then there were some side effects mentioned. And some of those side effects were very interesting for most of the purposes, and some perhaps could work without. And so I think this is about making it explicit what researchers think about that. And we also had a proposal that we'd like to see some kind of repository, which probably is not posted by the DPAs, because then it would automatically be said, this is now the thing that's state of the art or so. But something where we see, and it could be combined with certification, where I assume that they have a good level, but, well, because we are not doing the checks ourselves, there will be criticism as well. But that a kind of neutral organization can deal with that. And that is also always a call for send us, for example, your hacks, that we can assess whether it's really good or not. Or that we have learned now, and it's now not good anymore. But only paying blindly that this is the marketing statement on the brochure page number 1, this won't work.
Next question.
Hi. I really liked Woody's comment. As you can imagine, this is Malavika from Digital Asia Hub, Hong Kong. The idea of consent and meaningful informed consent is even more contested in the developing world. And at a recent conference, someone made this very provocative statement about how, with no other fundamental human right, do we have the idea of trade-offs and bargains. We don't waive things like the right to free speech. Why is it so common in the privacy universe that it's okay for us to say kiss goodbye to all of our rights? You don't have a free speech bargain, but you do have a privacy bargain that's very well understood. So I was wondering if either Woody or other panelists had thoughts about what makes privacy so different that we're willing to trade in this relative to other human rights.
That's a really excellent point. And it's one thing that I've thought about this a lot, and I think that it comes down to when you articulate the values of privacy beyond the amorphous sort of standard of privacy. What are we really trying to protect? The value that often comes up is autonomy, the right of self-determination. And somewhere along the way, this got enshrined as the sort of litmus test for whether privacy was being respected. Maybe because it was easy, maybe because it was pioneering. But for whatever reason, we have an entire framework based upon the notion that if we sort of bestow with you the right to determine for yourself how your data is used, then we've effectuated that. But for the exact reason that I think you just articulated, it seems awkward when compared to some other rights, and maybe it's just because it's so twined up with the value all the time. That's just my thoughts.
Well, I would argue that with the framing of the question, I think we give away rights all the time. Think of freedom of movement. Most of us are employed, I assume. When you sign your employment contract, it considerably limits your freedom of movement, right? You consent to your boss telling you where to go. Even with freedom of speech, which I agree is a bit of a special category, but even there we have many examples where people sign non-disclosure agreements, secrecy obligations, so you also trade off that voluntarily. I think the primary issue is that privacy comes in many more situations, so the issue arises far more than with many of the other rights. And it's particularly the notion of informed consent. With the other rights, you roughly know the consequences of what you're giving away or limiting your own rights to. And with privacy, that's far more difficult to proceed. So I think the issue there is more on the informed part.
Okay, we're a very quick question and quick answer.
Okay. My name is Bruno Bioni from nic.br in the University of São Paulo. Sometimes we talk about design or by design with something which is new, but actually if you take like the history of consumer protection, you know, when you talk about food, cars, drugs, all the time you can see this kind of regulatory approach. So I'd like to know if you can establish this kind of correlation and if it would be useful, you know, just take a look for the consumer protection history and try to establish some bridges on that.
Woody, 15 seconds.
15 seconds. I completely agree, and if you want a really good example, you can look to a lot of litigation in the United States over the automobile industry, and the approach that the FTC has taken with respect to sort of blending notions of unreasonable or unfair design, which is a great place to start from.
Okay, thanks. We need to wrap up now, and in the wrap-up process, I'm just going to give each of the panelists the chance to quickly give a sort of a takeaway line, and then we'll wrap up. Barbara?
Okay. So, I agree with everything that was said here, but I still don't have answers for my initial questions. I still think that Article 25 is too vague to be too abstract, but I agree with Marit, so we need to be more positive. And this is a start, so I think we all need to start thinking about this and actually come up with at least not so good ideas in the beginning, but at least the ideas that will improve in the long term.
The more cynical wrap-up would be data protection is too broad and we're trying to solve too much with it. The constructive part of that is, particularly when the issues that Woody and also Marit raised are other types of challenges to your autonomy, should not necessarily be addressed by data protection law. And I think we should avoid the reflex of, because we have a GDPR, that we try to solve all the problems that we have with the internet simply by this instrument, whereas, for example, consumer law is an excellent example of another area in which you could, I think, better find the solutions to manipulation and the other issues there.
And I will repeat my call. If you have to offer something to Article 25, please do so. And if you don't have to offer something, please demand it.
Design protections can be beautiful, but they have to be about more than data and more than consent.
That was beautiful.